My name is John Taylor and I'm the Chief Executive of ACAS. I'm pleased to introduce this DVD, which will give you an excellent background to what employment tribunals are like, as well as, we hope, as answering the most frequently asked questions about them. Whether you're an employer, an employee or an advisor, this is a useful starting point if you are unfortunate enough to be involved in an employment tribunal claim. Now, I say unfortunate because the best advice I can give you is to avoid tribunals if you possibly can. It's always better to try to sort out disputes between employers and employees in a positive and friendly way that avoids conflict. 3/4 of the tribunal claims that ACAS deals with are resolved without needing to go to a formal hearing. This may sound a lot, but it isn't surprising when you consider the cost, disruption and the stress that tribunal cases can cause to everyone concerned. Our professional conciliators have years of experience in helping to resolve employment disputes, and this DVD contains advice from one of them about how ACAS can help you. Our conciliation service is impartial, confidential and free, and I'd urge you to contact us at the earliest opportunity if you become involved in a workplace dispute. You can get details of our services, including our free helpline and website, on this DVD. Your guide through the tribunal process is Christopher Knott of Capital Law, a firm that runs a number of joint training courses with ACAS. He will give you a valuable background to the tribunal process. I'm sure you'll find this DVD useful.
Thank you, John. That's good advice. Of course, sometimes employers and employees can't agree on how to resolve their differences, no matter how hard they try. And these cases often end up in an employment tribunal. When they do, you need to be prepared, whether you're bringing a claim or someone is bringing one against you. But first, let's look at our case study. Julian Kirby has been dismissed from working in a pub run by Hannigan's Brewery. He thinks he's been treated unfairly, so he's complained to the employment tribunal. He's one of many former employees who bring unfair dismissal complaints. Unfair dismissal is the most common type of claim in the UK's employment tribunal. But there are other common complaints, for example, for discrimination or unpaid wages. Some people who bring claims to employment tribunals hire lawyers, and in the case we are about to see, both parties are represented. Now, this is to show you how professionals conduct a tribunal case, but you should remember that you do not have to have legal representation. Many people choose to represent themselves. The tribunal system is designed to be as simple and informal as it can be in the circumstances. If you're not represented, then the tribunal will do its best to help you understand the legal issues and to get your case across. There are hundreds of legal firms across the UK who do employment tribunal work. Some charge by the hour, whilst others charge on a no-win, no-fee basis. And there are also employment law consultants who provide a similar service. Alternatively, many people get help from a trade union or an employers' federation or the Citizens Advice Bureau. It's not for me to say who you should use or whether you should represent yourself. It's really down to what you're comfortable with.
Seen our new menu?
Yeah. Brought Mary here on Saturday night, actually.
What do you reckon?
Excellent. Couldn't fault it. We both had a steak. Superb.
Good, good.
Listen, Phil, I think there's something you should know.
Hmm?
Between you and me, there wasn't a lot of tail action going on, if you know what I mean.
Go on.
Yeah, well, I was at the bar, right?
Five will do, mate.
Nearly the cheapest run I've had all night. Cheers, mate. Keep the change.
Again?
Free drinks. A lot of the punters seem to be getting them. I just couldn't believe it.
Listen, guys. This month's figures are out again. Is there anything either of you want to tell me?
There shouldn't be.
I don't really...
I'll help you out a bit. We've discovered what the problem is. We know about the free drinks. Any explanation from either of you?
No, I'm not sure.
George?
Sorry, Phil. I can't shed any light. Maybe it's the tills.
We're not stupid. Punters aren't paying for their drinks. That's not how a business works. You're suspended, both of you. Go home and have a think about things and come to my office on Thursday.
Thursday?
For a disciplinary. And I'll be expecting the truth. I suggest you both consider your positions very carefully. If you want to, you can bring along a work colleague or your union rep.
But who's going to look after this place?
Never you mind about that. I've got no choice here, boys. It's gross misconduct. I can't have you back. You've got to go.
So, Julian Kirby was dismissed. He appealed to the chairman of Hannigan's Brewery.
Look, I've heard enough. You've given me nothing that would make me want to overturn Mr. Maxwell's decision. The evidence is there. We can't just ignore this sort of thing.
Here, we see Julian Kirby filling out his claim form to the tribunal, the ET1. This form can be obtained from a variety of locations, but try the Tribunal office or the Citizens Advice Bureau or the web. Here, Julian is completing his form online on the Employment Tribunal Service website. The completed form has to be lodged with one of, but any one of, the tribunal offices around the country. Strict time limits apply for different cases, and in unfair dismissal cases, the time limit is 3 months. There are tribunal offices throughout the UK to receive the claim. Our DVD focuses on tribunal procedures in England and Wales, and slightly different procedures apply to Scotland and Northern Ireland. It is compulsory for the employee to fill in an ET1 form and for the employer to respond on an ET3 form. The ET1 form is copied to the employer and to ACAS. The employer must then respond using the ET3 form within 28 days, unless beforehand they're granted an extension by the tribunal. If they're not, the tribunal chairman has the power to decide the case immediately based on the ET1 claim form alone. Even if the tribunal doesn't do this, there's a real possibility that the employer will not be allowed to defend the claim. Each party must set out at least the basic facts on which their claim or response is based and what the claim or response actually is. The ET1 and ET3 forms highlight the minimum information you'll need to provide. And if this isn't provided, the tribunal may send the form back to you. This could result in delay and you missing the deadline for the presentation of your claim or response, which I referred to earlier. The person making the claim is referred to as the claimant, and the defending party is the respondent.
I think sometimes what happens is that once the litigation process starts, parties take entrenched positions, and sometimes they actually don't stand back and work out what they're actually fighting about. Often it can be only a very modest sum of money, because if it's an unfair dismissal claim, the claimant might have got a new job at roughly the same money within a matter of weeks or a matter of months. And ultimately the parties, if they haven't stood back and actually rationalised what the case is about, end up spending a lot of time and resource over fighting about not very much.
These are the tribunal rules in England and Wales. I downloaded this version from the internet. And the Employment Tribunal Service will send you booklets explaining how the tribunal system works. And this DVD is about how tribunals work in practice. Simpler or smaller cases, such as for unpaid wages, will normally be fast-tracked and heard quickly. The tribunal will set aside much more time to deal with complicated cases, such as involving discrimination. And the tribunal will generally give directions for the parties to do certain things in preparation for their case. Make sure you follow these directions carefully. Now, the most common are to prepare a schedule of loss, where the claimant sets out the value of their claim, the disclosure of all relevant documents, regardless of whether they help your case or not. And if the other party withholds a document, ask the tribunal to order them to disclose it. There's the exchange of witness statements, and there's the preparation of the trial bundle, about which we'll talk more later. There may be a case management discussion, particularly in longer or more complicated cases, where the tribunal may wish to discuss the preparation for the case with the parties in more detail. And there may be a pre-hearing review, where the tribunal may conduct a review to decide a particularly important issue in a case, such as whether it was brought in the correct time limit. When the tribunal sends the parties the date for the hearing, it will specify how much time has been set aside to hear the case. Now, if you think you need more time, tell the tribunal and give your reasons why. The tribunal will do all it can to conclude the hearing in the time allotted, even if it involves it using its powers to limit how long witnesses can be questioned or cross-examined, such that it can finish the case on time. As soon as it receives the ET1 and the ET3, the tribunal sends a copy of them onto ACAS. Let's find out why. Let's see what role ACAS has to play. Tony, you're a conciliator with ACAS. How would you describe your role in a tribunal case?
Basically, Chris, my role as a conciliator is to try and help the parties reach an amicable agreement, resolve their differences, without the need for a tribunal hearing. ACAS actually has a statutory duty to offer conciliation in most kinds of tribunal cases.
So how would you go about doing that?
Well, once we've got the tribunal case papers from the tribunal office, what I need to do is to contact the parties. I need to do that as quick as possible because the time for conciliation is limited. In many cases, it can be as little as 7 weeks. So that means I'll normally make contact through telephone, but in certain cases we might arrange a meeting, or we might even have both parties together for a meeting.
Well, what would you do if someone was represented by, say, a lawyer or an employment consultant?
The conciliation process doesn't alter at all, but what that would mean is that I would deal directly with the representative, not with their client. I wouldn't speak to their client unless I was specifically asked to. That's important, really, then, that individuals understand, if they've got a representative, that their representative knows what they are looking for from the tribunal process. Because if we did reach an agreement through ACAS, it would be legally binding.
So what do you say to the parties or their representatives when you first make contact?
The first thing I need to ensure is that people understand the role of ACAS and the role of the conciliator. So do people know that ACAS is an independent organisation, we're government funded, and that conciliation is a free process? Then I need to make them aware of the actual role of the conciliator. The most important aspect is that the conciliator is always impartial. It's important that people understand that we actually have no vested interest in the outcome of the tribunal. We can't actually make decisions on their case, and we don't represent them. Other than that, I would make them aware of the fact that the process is confidential. People need to be aware that they can discuss the case freely with us, and that we won't actually pass on any information unless they want us to. The other side of things is that it's voluntary. People need to know that actually, if they don't want to go ahead with conciliation anymore, they don't have to. They can opt out, and they can go ahead to a tribunal hearing.
Well, what sort of things can you tell them?
What we'd be telling them is, well, what does the employment law say in relation to their case? What might be good practice? How does the tribunal process work? What does the tribunal look for in the kind of case that they're actually dealing with? It's providing that information and giving them that kind of information, allowing them to really work out for themselves what the strengths and weaknesses of their case might be.
And once they understand the strengths and weaknesses of their case, what options do they have in the conciliation process?
Once the tribunal complaint has been lodged, there are several options that are open to them. The first would be to settle the claim through ACAS, through conciliation, and around 40% of cases that we handle are settled in that way. Alternatively, they could opt to settle through a compromise agreement. In that situation, the individual would need to be independently legally advised, though. Other alternatives: if the case was an unfair dismissal case, they could opt to go to arbitration, where the case would be heard by an independent arbitrator appointed by ACAS, not by a tribunal hearing. The advantages of that potentially are that it's a private hearing and that it remains confidential. The other options would be the individual withdraws the claim, or alternatively, it ends up at a tribunal hearing. Around 25% of all claims that are lodged end up at a tribunal.
So what else can you do as a conciliator?
The first thing to do really is probably listen to people. People are often emotional or perhaps feel quite sort of strongly about the issues. So listen to them, see what they've got to say about their case and what's happened to them. After that, it's about explaining to people, well, how do we look at the case in relation to the employment law? How do we look at it in relation to good practice and the tribunal process? And what we're really trying to do through that is to minimise those areas where both sides disagree, try and maximise the areas where there is actually agreement. And that process is what actually leads to a settlement and an agreement.
Well, you've mentioned looking at the case from a legal viewpoint, but conciliators aren't lawyers, are they?
No. Obviously, we're thoroughly trained and we deal with a lot of cases. We deal with over 300 cases a year, so we build up experience very quickly. Obviously, it's important that we also make clear to people what we can't do. We can't advise them about their case because we have to be impartial. Therefore, I couldn't advise somebody whether or not I thought they'd got a strong case or a weak case. I couldn't help them prepare their case, and I couldn't advise them what to offer or what to accept if an offer was made.
Yes, you're not going to take sides in any way, are you?
No, as I said before, we don't have any vested interest in the outcome of the case, and we have to remain impartial.
What happens if the parties do manage to reach an agreement through ACAS?
The first thing I have to do is to ascertain to my own satisfaction that we have actually reached an agreement. What I mean is that I have to be 100% clear that both sides are happy with the agreement and that they fully understand what the agreement entails. Once I'm happy with that, I can notify the tribunal of the fact that we've reached an agreement. We can have a legally binding agreement actually verbally before anything is actually signed in writing. And once I've notified the tribunal, they will take the case out of the list of hearings. What I would then need to do will be to actually put that agreement into writing. It would go onto a form known as a COT3, an ACAS form. That would be signed by both parties. Both parties would keep a copy, as would ACAS.
And what would a typical agreement contain?
Typically, the most common type of agreement would be to settle the case, to settle all claims in return for a sum of money. One of the advantages of conciliation, perhaps in comparison to the tribunal process, is that typically the tribunal can only award a sum of money, when often what the individual might be looking for might be other things. Through conciliation, we can actually put anything into an agreement, provided it's legal and provided both sides agree. So the individual might be looking for perhaps an apology, perhaps a reference, perhaps they're looking for a reassurance that the kind of treatment that they actually suffered won't happen again. From the employer's point of view, they might be looking for a confidentiality clause. All of those sort of things can actually be incorporated into an agreement.
Whereas a tribunal can't order them?
No.
So why should people use conciliation?
From an individual's point of view, or from the employer's point of view, they've got nothing to lose by using conciliation. We've seen it's a voluntary process. It also provides a way of exploring settlement, exploring the situation in perhaps a more informal environment, perhaps a safer environment. They also retain control. We actually reach a lot of agreements because it's the parties' agreement. It's not an ACAS agreement. It's for the parties to come to an agreement and it remains in their control, unlike the tribunal, where obviously, ultimately, the tribunal makes its decision and issues its judgment.
It must be much less stressful.
It's much less stressful for people. It can be less expensive, can be less time-consuming. And I think the stress side of things perhaps shouldn't be underestimated because the tribunal process of its very nature is adversarial, and as I said before, it is a less formal approach through ACAS, and through conciliation people will often perhaps take things from a neutral third party that they might not from the other side.
There's a lot to be said for it being private and not on the public record, isn't there?
There are certainly advantages to conciliation, and that might be a prime reason why somebody would look to try and reach a settlement, because obviously the tribunal hearing is public and there could be the risk of adverse publicity.
And what does the tribunal do whilst conciliation is going on?
The employment tribunals can do every aspect of managing the case apart from actually listing the case for hearing. So unless the employment tribunal tells you otherwise, you need to carry on preparing your case. Because ultimately, Chris, if conciliation isn't successful, then the case will be heard at a tribunal hearing.
Finally, Tony, and in the round, what is your advice to people thinking of using conciliation?
Why not try it? We said they've nothing to lose by using conciliation. They might reach an agreement that they'll be happy with. If not, they've got the right to go to the tribunal and for the tribunal to actually determine their case. At the end of the day, it can be less expensive, it can be less time consuming, it can be less stressful, and any agreement they reach will be their agreement.
But the disagreement between Julian Kirby and Hannigan's Brewery couldn't even be resolved by ACAS, so it has to be resolved by a tribunal hearing. There's lots of preparation required, so start as early as possible. And whatever else you learn from this DVD, there's no substitute for careful preparation. Also, read and follow all the letters received from the tribunal and ensure that they're complied with. If the hearing has to be postponed because you've not done what the tribunal requires, you may have to pay some costs to your opponent. So, let's go to the hearing.
Tribunal hearings normally take place in their offices all around the country. They're usually in anonymous office buildings such as this one. So, let's go inside. In the tribunal's reception area, you'll find a list of the cases being heard that day. Check the name of your cases on the list and check which room it's going to be heard in. There are 3 cases being heard in this tribunal today, and ours is going to be in Tribunal Room 1. Our chairman today is going to be Mr. Wong. Then, check in and let the tribunal staff know that you've arrived. Hello, I'm in the case of Kirby against Hannigan's Brewery. The tribunal staff will show you to one of 2 waiting rooms, one for the claimant and one for the respondent. Wait there. The clerk will let you know when your case is due to start. This is what a tribunal hearing room looks like. It's quite different from a courtroom, but tribunal rooms are almost all the same across the UK. Nearby is a separate retiring room which